Sorry about that. My colleague and I were discussing some high-level criminal law issues. But right now, we're going to invite everyone back to the sixth meeting of the Senate Judiciary Committee. At this time, members, does anyone have any guests they'd like to introduce? Seeing none, members, just please silence your cell phones. Mr. Secretary, please call the roll.
Senator Carroll.
Here.
Senator Deneen.
Here.
Senator Neal. Senator Nemus.
Present.
Senator Reed.
Here.
Senator Stivers. Senator Thomas.
Here.
Vice Chair Wheeler.
Here.
Chair Storm.
Here. It appears we have a quorum present and are duly constituted to do business. At this time, we'll go ahead and proceed to Senate Bill 131. That is first on our agenda. It's an act relating to wrongful conviction compensation sponsored by Senator Robin Webb. And once you're seated, if you could just identify yourself for the record and any guests you have, and you have the floor.
Thank you, Mr. Chairman, committee. After about 20 years serving on this committee, it's good to be back before you in this, even in this capacity. But yeah, today I've got some guests with me, and I'll let them introduce themselves.
All right, good morning. My name is Aaron Riggs.
Make sure your microphone's turned on. There you go.
Thank you. Good morning. My name is Aaron Riggs. I'm the director of the Kentucky Innocence Project.
My name is Michael Von Allman, and I was wrongfully convicted in 1983 in Louisville, Kentucky.
And I'm Senator Robin Webb, represent the 18th District. I'd just like to say Senate Bill 131, the topic's been around for a long time. And this bill has been in the House and where it passed Judiciary Committee last year and got tied up in some time frames. But I hope that we can move this forward. There's been 23 known exonerations since 1989. With innocent Kentuckians losing a combined year total of 220 years of their lives. And Mike and some of our audience members are among those. So 40 states and the federal government have a system for compensation. And what I think we've done with this bill, along with the Help of the Innocence Project, who I've worked with for decades on other issues as a criminal law practitioner, is try to narrowly define who would be eligible, have a rational formula for compensation after a very stringent protocol with in the judicial system, and we've I think alleviated a question of pardons regarding pardons that was brought up earlier. We've narrowly defined this thing, and at this time I would just ask Mike to briefly give a synopsis of his experience with the chairman's indulgence.
That's fine.
Thank you, Mr. Chairman, members of the committee. Thank you for allowing me this opportunity to speak of my life experience. My story started one Friday night in 1981 when this fella went into a bar in South Louisville, abducted a young lady, took her to a park, raped her, sodomized her, and robbed her. The victim noticed this guy staring at her at the bar all night, and she was able to put together this composite drawing of the perpetrator. Blue eyes, driving an old green car. This picture was circulated on Saturday night. Friday night, Saturday night, the picture's being circulated. Sunday night, this is me looking exactly like that guy, minus the blue eyes. Walk into this very same bar, order a Sterling mug and a frozen mug, not having a clue anything in the world was different. But the folks in the bar were looking at that composite drawing, doing a good Samaritan thing, jumped in their cars when I left, followed me home in my blue Volkswagen to the apartment complex that I lived in, pulled in next to my neighbor's green 68 Chevrolet, and that turned into a 30-year sentence that I ultimately served 11 years of that in prison, 16 of it on parole, before I found out about the Kentucky Innocence Project. Had no idea they existed. What had happened was the Kentucky Innocence Project got a grant from the Justice Department, and because DNA had gotten us that far along that the federal government was starting to study the issue, Kentucky got one of those grants, published it in a newspaper. I read it, contacted the Kentucky Innocence Project, and they uncovered in what is lightning speed for wrongful conviction investigations. Lightning speed got this case together, and they were also able to discover in the files the hair samples from the rape test kit that they had originally taken. And it turned out there were 16 hairs that they could test with DNA. After they tested the hairs, they turned out to all be of female origin. So the hair sample that they had on me originally was all her own hairs. They really had no hair samples. But the Innocence Project had put together a case so tight on this guy that when the results came back not inconclusive, they filed this case anyway. And without hesitation, the judge had a hearing on it. Without hesitation, he vacated the sentence, and 27 years of me being a convicted sex offender ended with the stroke of his pen. Finally, this was over. We found out how simple this mistake was, how unbelievable this mistake was. But when you take 27 years as a convicted felon and the end result is, oops, we're sorry, it doesn't sit right with anyone. If anyone in this room was to experience the same thing, you would be saying there's a lot of zeros missing off of these numbers. An incredible experience, certainly deserving of some compensation. And we not only need to address this issue for the folks on my side of it, we need to address it for the other side of the issue, those victims, that actual victims of crime, whose families murdered. We have a case in Louisville where the actual perpetrator was discovered when he went to jury trial because of the wrongful conviction ahead of him. The jury couldn't cross the threshold of reasonable doubt. This murderer walked the streets, and that family will never see justice for their loved one. We have an almost exact case going to be ruled on shortly from Western Kentucky. A family that's going to live forever with the injustice of the death of their daughter. And you have my case, a lady that's, I'm assuming, is still in Jefferson County. Every night that this news is on the news, she's reliving one of the most horrible events in her life. This issue needs to be addressed just so that we deliver justice, so that we take care of the folks that endured the hardships of imprisonment. I urge you all to vote positively on this case.
Thank you, Mike. Mr. Chairman, if I may, I've heard Mike's story, and of course I've been familiar, you probably are too, as many other wrongfully convicted individuals throughout the country, but we do have them here. And I just want to address a little about perhaps the fiscal side of this. We have a very rational formula in the bill. I think it's you can't quantify what Mike and other individuals have lost, but certainly I think the state can allow a threshold. You know, he was released with no assistance whatsoever, just turned back into society with no reentry services. You know, that would maybe. So this bill would also address that to some degree, but we have, with the technology that we have now, and since I've been in the General Assembly, we made great strides with DNA. We're trying to upgrade our labs. We're trying to do all those things. So the pool of wrongful convictions in a perfect world is going to dwindle with the emphasis on technology and proper utilization and burdens of proof standards. So we're looking at a fiscal note here, but we have a pretty good idea about what that would be, and then what an annual cost would be. I did want to bring that up, but that's the fiscal side of me, but that we're going to have to address as well. But I do want the committee to know that, you know, we hope, it is our hope that we don't have any more. But certainly from a fiscal standpoint, with technology being what it is today, those case numbers are dwindling. You know, I was practicing back in the day when those inconclusive hair samples were often used against defendants without any real match because the technology wasn't there. Now we've got better technology. So I would just ask if Aaron had anything to add, if again, with the chairman's indulgence.
We have a question from Senator Nemus. Would you like to go ahead and ask your question now, Senator? Okay.
Yes, thank you, Mr. Chairman and the committee. All that I would add, with Mike's story and Senator Webb's testimony on this, really what we have right now is a system where individuals have gone to prison for crimes that they have committed. They serve their time and are released after that sentence. They enter society with more support than individuals who go to prison for crimes they haven't committed and are exonerated. They are put back on the street really without any sort of resources. What this bill is aimed at is narrowly tailoring that circumstance so that they are given the support, given some modicum of justice. No one can give them back what was taken from them, but this at least offers them support to rectify that injustice.
Senator Nemus.
Thank you, Mr. Chairman. It's a little more of a statement, if you don't mind. This from my neighborhood, Mike. I raised my family right along there in the South End where you lived, and the bar was close to where I grew up. So it's kind of personal. And I thank the Innocence Project because at first y'all were bad-mouthed as being you just letting people off, trying to get them off. The police didn't do their job and stuff. But that's not the case. The police may have done their job. It just was antiquated what they had to work with. And I worked in the LMPD property room, and it's something you might want to look at as the property rooms, make sure they keep the evidence in case it's needed in the future. And there's no way we can repay this man or any other ones in this situation. But what it does is it shows that we accept that we made a mistake and that we want them back into society the best that they can be. So, Senator Webb, when you're talking about reentry programs, that is something we need to look at too.
Yeah, and I appreciate that. And if I could just briefly respond, I was going to add, I'd like Mike to tell the committee where he is in life now and what he does. He's a businessman and what he's done since he has been out.
Really, my story is two parts. First, wrongful conviction, and the second part is the recovery from the wrongful conviction. I got out, and within weeks, I realized I had to make some kind of career move rather than just going by the rules of my parole, which was maintaining gainful employment, showing a check stub every week. I realized I had to make a career decision. One day I opened up the newspaper and plumber's helpers was wanted was a decision I made right there. I'm going to be a plumber. Pursued that as went straight to work as a plumber. And I'll share a little story with you. Part of my parole was not only telling my employers that I was a convicted felon, but I had to report, and this was before the sex offense registry. I had to report to them I was a convicted sex offender. And as I put my applications in and would be hired, then I'd tell them, hey, I'm sorry, but now I got to tell you I'm a convicted sex offender. And always the report was, what are you telling me that for? You mean you can't be to work tomorrow? I'd say, no, I just got to be there. Same way with the plumbers. When I put in my application for that, the guy hired me. I went out to the field. They gave me a pick and a shovel and gave me the hardest earth I've ever seen in my life and told me to put a ditch in from here to there for a pipe to go in it. For days I worked on this ditch and finally they realized my work ethic was more valuable. They moved me off to something else. About a month later, I found out that the word from the office from the guy that hired me, after I reported that I was a convicted sex offender, he reported to the guys in the field, work him until he quits. I didn't quit. I kept working. Finally worked my way into an apprenticeship program where I did plumbing for I'm a retired plumber now. Still get the phone calls. So I've recovered well. Plumbers do well. I did well. Life is well now. But there's still this injustice, this wrong, that some form of right is manifested in passing this bill into law. I appreciate your positive vote on it.
Thanks, Mike. Any more?
Senator Thomas.
Senator Webb, I don't want you to misunderstand the intent of my question. I like your bill. I will support it. But in the work I was given here, the folder I was given here today, I don't see a fiscal note for your Senate bill. And so I was wondering, it's Senate Bill 131. I wonder if you have a fiscal note somewhere.
There will be a fiscal note. There's no question, and there's a chance that this might go to A&R as well, which I'm on that committee. But we would anticipate what the 7.1 million total overall, and then with 100,000 a year as it levels out, and hopefully those claims are dealt with in an expeditious manner. And then maybe, like I said, with technology and our caseloads being what they are, and identified potential exonerees would be about 100,000 a year. Is that correct, Aaron?
Yes, Senator Thomas. Essentially, there are 23 recognized exonerations in Kentucky. 8 of those have had civil settlements that exceed anything that they could be awarded under this bill, and this bill specifically exempts their ability to recover under it. So what we're really looking at from a backlog of existing exoneration standpoint is about 15 individuals who could apply, and based upon the amount of time that they spent in prison, we estimate about $7.5 million for that group if everyone were to seek this compensation and be successful at it, which there's no guarantee that both those things would be true. And then going forward, if there is, say, one exoneration a year, it would depend on how long they had spent in prison. But yes, if they had spent a short amount of time, it could be about $100,000. If they had spent, most exonerees, there's an average of about 10 years in prison. So just going off that average, they would be looking around $650,000.
And there's also can be a cost savings in light of the potential civil settlements and from everybody with the police on in that chain. That's going to be included in a contest of a wrongful conviction on a civil side. This is an avenue to thwart that procedure, save the state money in that regard, and allow this structured, more known expenditure, if you will, than having to deal with that and the cost savings of taking resources and time away from agencies and whatnot. That's not real quantifiable in an analysis, but that too is a plus.
Thank you for the answer, Senator Webb.
See no further questions at this time. Oh, yeah, Senator Wheeler has a question.
Senator Webb, and thank you for bringing this bill, and I appreciate the work that was done to tighten up the pardon section in particular. I think that was something that, as we saw from some of the things done with our last governor, I think that needed to be something that we needed to make sure that these people are truly innocent, like the gentleman sitting there to your left. Now, if someone were to pursue a claim, I see there's an offset provision in here for other civil settlements. Would pursuing a claim under this section preclude any other actions against possibly other negligent or parties with a department or anything like that if you were to take compensation under this chapter?
Senator Wheeler, it doesn't preclude any other civil action that may be taken. What it does is just protect taxpayer money from, if you do seek compensation under this statute, then any reward or settlement that you might receive in a civil suit, you must pay back the state or become ineligible to seek this. Well, one of the things, especially with Mike's story, is there simply wasn't real misconduct by anyone. The police did the job that they could based upon the identification, and in cases like that, there really is no civil avenue that he can pursue. So what this bill is hopefully aimed at and will accomplish is helping individuals in situations like his, where even if they don't have that civil remedy available to him, they can still seek some compensation.
I just was, like I said, wanted to make sure we're not precluding any other avenues as well. So, yeah, thank you.
Excellent question. I see no other questions on by any members. This motion on the bill and a second motion by Senator Nemeth, second by Senator Wheeler. Mr. Secretary, please call the roll.
Senator Carroll. Aye. Senator Deneen. Aye. Senator Neal. Aye. Senator Nemeth.
Aye.
Senator Reed.
Aye.
Senator Stivers. Senator Thomas.
Aye.
Senator Wheeler.
Aye.
Chair Storm.
With 8 yes votes, 0 no votes, and 0 pass votes, Senate Bill 131 is passed and will be reported with favorable expression that same should pass. Thank you, Senator.
Thank you all.
Thank all of you.
At this time, we'll turn to the next item on the agenda, which is Senate Bill 193, sponsored by Senator Deneen. Senator, once you get situated, please identify yourself and your guest, and then you have the floor.
State Senator Matt Deneen, representing the 10th District.
And I'm Kelly Easton on the Kentucky Court of Appeals 2nd District.
Thank you, Mr. Chairman and committee members. I'm very glad to bring Senate Bill 193 today after consultation with my good friend and fellow Hardin County and Judge Easton, and recent court cases that have brought this issue forward by our Kentucky Supreme Court, where they called upon the General Assembly to clarify some language so that these folks in our probation situation that may abscond or have other violations during their probationary time period, this bill simply puts in a time period for our judges to be able to take a look at those violations in a reasonable amount of time, even though their probation has maybe come to an end before they get a court hearing. And we don't want those folks to that have violated those probation opportunities to go without some sort of accountability. So with that said, I'll kind of give you a brief summary and a short story here of where this bill came from in its origins. KRS 533.020 establishes the sentences of probation, probation with an alternative sentence, and conditional discharge. And it provides no order for probation or conditional discharge shall exceed 5 years, except when extended or shortened by a duly entered court order or modified by the DOC. And why I want to share this story here, why this bill is important. And recently, the Supreme Court of Kentucky found in Commonwealth versus Tapp that the defendant entered a guilty plea to several drug offenses and was sentenced to 1 year in prison, probated for 1 year. The defendant was subsequently cited for traffic violation on January 31st, 2013. The circuit court served a bench warrant for the defendant's arrest, and the dates here are important. On February 12th, at the probation hearing, the defendant argued that the circuit court lacked jurisdiction to hear the matter because his probationary period had expired on February 2nd. At the probation hearing, the defendant argued that the circuit court lacked this jurisdiction, and in response, the Commonwealth argued that the warrant issued by the court told the expiration period. The circuit court found that it retained jurisdiction and revoked the defendant's probation. The Court of Appeals reversed, concluding that the warrant expired when served, and therefore the circuit court lacked jurisdiction. The Supreme Court affirmed holding when a warrant remains pending until the defendant is brought before his court, at which time the court may extend the probationary period for a reasonable time until the revocation hearing can be held. And two, because defendant's probationary period was not extended, the court lost jurisdiction to revoke his probation. So, in this situation, the court lost its ability to hold that person accountable. And so this is why it's very important. Since 2016, judges and prosecutors have had to be very careful to extend any period of probation with alternative sentences or conditional discharge at the defendant's first appearance, or risk losing jurisdiction. Senate Bill 193 would do two things. One, toll any period of probation with an alternative sentence or conditional discharge between the issuance of a warrant and the defendant's first appearance for an alleged violation of his or her terms of probation or conditional discharge. Then the court gets 60 days to decide if the violation occurred and could extend probation or conditional discharge. For example, if a defendant is on the run for 90 days, that time does not count towards his or her period of probation or conditional discharge. And number two, it gives the court 60 days after the period of probation or conditional discharge to have a hearing on an alleged violation of probation or conditional that occurs within the last 60 days of the period of probation or conditional discharge. The time period of 60 days in some of our rural areas, these courts only meet once a month to deal with this situation. So this is why the 60-day time period was put into the bill. And at this time, I'll turn it over to Judge Easton, and I'd like to have his comments on why this bill is so important.
Thanks, Senator Neen. Thank you, Mr. Chairman and members of the committee. As Senator Deneen indicated, I'm Kelly Easton, and I'm now on the Court of Appeals of Kentucky, but for over 20 years I was a circuit judge in Hardin County, and so I dealt with felony probation a lot. This bill will amend the statute to make clear when probation ends, and it will provide, I believe, a sensible and clear process for ensuring successful completion of probation. In felony cases, as we've indicated here, probation can be up to 5 years. But the probation expires unless there is a warrant pending for a probationer when the 5 years are up. Now, this raises a couple of concerns that this bill will address. First of all, there's a potential for serious violations, and I've seen this, to be committed in the last days or even weeks of the 5-year period, but there is no process. And so there's nothing that can be done about it as far as the probation sentence is concerned, unless a warrant somehow gets issued in time. So if someone commits an offense in the last week, the probation officer doesn't tell the judge doesn't know, that probation is considered as successfully completed. I would argue that that's not a successful completion of the full 5-year probation term, but it will be treated that way for expungement and other purposes. So under current law, we have a couple of options. If a motion has been filed about a violation, first of all, motions should be filed instead of warrants, if at all possible, because we're going to cut back on the amount of time people are in our jails. If a motion can be filed to address a probation violation, then that probationer is out of jail until the issue has been addressed. But if the hearing is not completed within the 5-year period, the court cannot act on the violation. it loses jurisdiction over the case. The TAP case that Senator Deneen was talking about is really a second in a line of cases that dealt with this. There's another case called Conrad versus Everidge, which said if you filed a motion but you didn't get the hearing done within the 5-year period, you cannot act on the violation. So this is the problem that I saw as a circuit judge. What has happened is warrants have become a last-minute option, sometimes adding unnecessary jail days to our overburdened system already. This bill, it tries to create a process that if we work with probation and parole, as I will explain briefly, this will cut down on that use of warrants.
Motion on the bill.
Seeing no questions at this time, we have a motion on the bill by Senator Wheeler. Do we have a second? Second by Senator Nemus. Mr. Clerk, please call the roll.
Senator Carroll. Senator Deneen.
Aye.
Senator Neal. Senator Nemus.
Aye.
Senator Reed. Senator Stivers. Senator Thomas. Senator Wheeler. Chair Storm.
I'd like to explain my yes vote briefly. I think this is a good piece of legislation. I do note that on page 3, and Judge, I just want you to clarify this, line 6, what the bill's saying is that you would have 60 days to schedule and complete the hearing, so the hearing would have to take place within that 60-day time period. Is that my reading of that correct?
Yes.
Okay, thank you. I vote aye. 8 yes votes, 0 no votes, 0 pass votes. Senate Bill 193 is passed and will be reported with favorable expression. Same should pass. Thank you, Senator.
Thank you, Chairman. Thank you, committee members.